I have heard defendants challenge evidence, argue with attorneys, and even question witnesses. But only once did someone walk into my courtroom, look directly at me, and calmly say, "I don't recognize this court." She believed that sentence would stop the proceedings before they even began. Instead, within minutes, it triggered one of the fastest and most unforgettable courtroom decisions I have ever made. By the time she realized what her words actually meant under the law, the trial was effectively over. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now, let me take you back to where this case truly began. My name is Judge Judith Harper. After decades on the bench, I've learned that people often misunderstand what gives a courtroom its authority. It isn't the building. It isn't the judge. It certainly isn't whether one party agrees with the process. The authority of a court comes from the law itself. That lesson became painfully clear in this case. The plaintiff was Daniel Carter, owner of a residential renovation company that specialized in restoring storm-damaged homes across the state. The defendant was Karen Reynolds, a homeowner who had hired Daniel's company to complete an extensive renovation after severe water damage. Daniel claimed his company had completed nearly all of the contracted work. Karen refused to pay the remaining balance of just over $18,000. Her explanation was simple. She insisted the workmanship was unacceptable. Daniel insisted every disputed item had already been corrected after multiple inspections. The disagreement eventually reached my courtroom. At first glance, it appeared to be a fairly ordinary contract dispute. Construction cases often involve competing inspections, photographs, invoices, and expert opinions. But this case took an unexpected turn before opening statements had even finished. As I explained the procedures to both parties, Karen interrupted me. She stood slowly, folded her arms, then looked directly at the bench. "I don't recognize this court." The courtroom became remarkably quiet. Spectators stopped whispering. Even the attorneys exchanged brief glances. Years on the bench have taught me never to react emotionally when someone challenges the court. People speak from frustration, from fear, sometimes from misinformation. What matters is how they respond once the legal consequences are explained. I calmly asked Karen to clarify her statement. She replied that she did not believe the court had authority over her dispute. She insisted she had researched the law herself. According to her, only a proper tribunal could hear the case. She repeated that she did not consent to these proceedings. Daniel Carter remained completely silent. His attorney simply closed a folder and waited. That immediately caught my attention. Lawyers with strong procedural arguments rarely interrupt. They understand patience can be more persuasive than passion. Karen continued speaking. She insisted every document filed against her was invalid. Every order was meaningless. Every hearing unnecessary. Then she looked toward the jury and confidently declared, "None of you have jurisdiction over me because I don't recognize this court." I made a note, not because her statement decided the case. It didn't. Courts do not lose jurisdiction because someone refuses to acknowledge them, but her position raised an issue that had to be addressed before any evidence could be heard. I reached for the case file resting on my bench. Inside was a document filed months earlier, one that Karen herself had signed under penalty of perjury. As I read the first page, I noticed a detail that immediately changed my understanding of the entire case. And before that morning was over, the very filing Karen had personally submitted would become the reason the trial came to an abrupt and unforgettable end. The second day of proceedings began with an atmosphere unlike most contract disputes I have presided over. The arguments about renovation work had almost become secondary. Everyone in the courtroom was focused on one question. Why had Karen Reynolds suddenly claimed she did not recognize the authority of the very court where she had been appearing for months? Years on the bench have taught me that timelines often expose contradictions better than cross-examination. People may forget what they said. Court records rarely do. Karen entered the courtroom with the same confidence she had displayed the previous day. She carried a thick binder filled with handwritten notes, printed internet articles, and highlighted legal phrases. Daniel Carter arrived carrying only 2 folders. One contained photographs of the renovation. The other contained procedural filings. He looked remarkably calm. That caught my attention. When litigants stop worrying about the facts and begin focusing on procedure, experienced attorneys know the case can change quickly. After everyone was seated, I addressed Karen directly. Yesterday you stated that you do not recognize the authority of this court. That's correct. And is that still your position today? It absolutely is. Her answer came without hesitation. I nodded. Then I opened the court file. Years of experience have taught me that every lawsuit tells 2 stories. One is told from the witness stand. The other is told through paperwork filed long before anyone enters the courtroom. I held up the first document. Miss Reynolds, do you recognize this? She looked toward the bench. It looks like paperwork. It is your answer to the complaint. She leaned forward slightly. I continued. This document was filed 4 months ago. She remained silent. It bears your signature. Another pause. It includes your mailing address. Silence. And directly above your signature, I looked down briefly before reading aloud. I respectfully request that this court deny the plaintiff's claims and grant such further relief as the court deems appropriate. The courtroom became completely still. Karen shifted in her chair. I watched the jury carefully. Several members immediately began taking notes. One looked back and forth between Karen and the document. Another slowly underlined something on the verdict notebook. I turned another page. Miss Reynolds, is this your signature? She looked at it carefully. Yes. And did you personally file this document with this court? Yes. Years on the bench have taught me that admissions made under oath often arrive quietly, but they carry enormous weight, I continued. So 4 months ago you asked this court for relief. Karen hesitated. Yes. And today you are telling this same court that you do not recognize its authority. She didn't answer immediately. Instead, she looked toward her attorney. He remained seated. He said nothing. The contradiction was obvious. Karen attempted to explain. I've learned more about the law since then. A reasonable statement. People learn new things every day. But learning new legal theories does not erase filings already made under oath, especially when those filings specifically request relief from the very court being challenged. I closed the file gently. The renovation dispute had not even begun. No witnesses had testified about construction. No photographs had been discussed. Yet, already the procedural record was raising serious questions as to Karen's credibility. Then the plaintiff's attorney stood. Your Honor, he said, before we proceed with evidence, the plaintiff has one additional filing that directly relates to the defendant's position regarding jurisdiction. I looked toward him. He held up a single page, thin Cybele. But the expression on Karen's face told me she recognized it immediately, and I realized that document might end this trial long before either side ever discussed the renovation itself. The third morning began with an unusual sense of anticipation. By then, everyone in the courtroom understood that the renovation dispute itself had become secondary. The real issue was whether Karen Reynolds could continue denying the authority of a court she had already asked to rule in her favor. Years on the bench have taught me that the law values consistency. People are free to change their opinions. They are not free to ignore the legal consequences of positions they have already taken. The plaintiff's attorney approached the lectern carrying the single-page filing he had referenced the previous afternoon. He requested permission to present it before calling any witnesses. I granted the request. The document appeared on the courtroom monitor. At first glance, it looked ordinary, a pretrial motion, one of dozens that pass across a judge's desk every week. But one paragraph had been highlighted. The attorney looked toward Karen. "Miss Reynolds, do you recognize this filing?" She stared at the screen. "It looks familiar." "It should." He paused. "You filed it yourself." The courtroom remained silent. He enlarged the final page. Karen's signature appeared at the bottom. "Clear, undisputed." I asked the obvious question. "Is that your signature?" Karen nodded. "Yes." The attorney thanked her. Then he directed everyone's attention to the highlighted paragraph. I read it aloud for the record. "The defendant respectfully requests that this honorable court compel the plaintiff to produce additional construction records and schedule this matter for trial." The words echoed through the courtroom. I lowered the document. Then I looked directly at Karen. "Miss Reynolds, can you explain why you asked this court to compel discovery and schedule a trial if you believed it had no authority over your case?" For the first time since the proceedings began, she had no immediate answer. She looked toward her attorney. He quietly reviewed his notes. He did not speak. Years on the bench have taught me that silence from counsel often means there is no satisfactory explanation. Karen finally responded. I didn't fully understand what I was signing. It was a different position from the day before. Yesterday she had insisted she had researched the law extensively. Today she claimed she had not understood the documents she personally filed. The jury noticed the shift immediately. Several members exchanged quick glances. One juror slowly underlined a line in the notebook that had already become crowded with observations. The plaintiff's attorney wasn't finished. He introduced the electronic filing receipt from the court's online system. It showed Karen had personally created the filing using her own account. The submission occurred at 9:14 p.m. Less than 3 minutes later, she logged in again and checked the case docket. Then again, the following morning, the timestamps told their own story. This wasn't paperwork filed by mistake. It wasn't something submitted by another person. The digital record showed Karen had actively participated in the litigation for months. She had requested hearings, requested deadlines, wrecked rulings. Only after the evidence began turning against her did she suddenly declare she did not recognize the court. That sequence mattered very much. I folded my hands and looked across the courtroom. The issue was no longer confusing. It was becoming procedural, and procedural issues often require immediate decisions. I informed both attorneys that I intended to hear brief arguments on the jurisdictional challenge before allowing the trial to proceed any further. Neither attorney objected. What happened during those arguments would determine whether this case continued or whether it would come to an abrupt end before the first construction witness ever took the stand. The fourth day of proceedings began without a single witness being called. That alone told everyone in the courtroom how significant the issue had become. The construction dispute had been temporarily set aside. Before we could discuss invoices, inspections, or repair work, the court first had to address Karen Reynolds' insistence that this court lacked authority over her. Years on the bench have taught me that jurisdiction is not a matter of personal preference. It is a matter of law. A litigant can not simply decide a court has no authority because the proceedings are no longer going the way they expected. I invited the plaintiff's attorney to present his argument first. He stood calmly. There was no dramatic speech, no raised voice. He simply walked through the court record. He reminded everyone that Karen had answered the complaint. She had filed motions. She had requested discovery. She had asked this court to compel the plaintiff to produce additional evidence. She had personally requested that this very court schedule the trial. Every filing carried her signature. Every filing invoked the authority of the court she now claimed not to recognize. When he finished, he returned quietly to counsel table. Then Karen's attorney stood. He argued that his client had recently developed concerns about the legal process and believed the court should first determine whether it possessed proper authority before hearing the case. It was an appropriate legal argument to raise. Every party has the right to challenge jurisdiction, but challenges must be supported by law and facts, not merely disagreement. I turned toward Karen. Ms. Reynolds, I want to ask you something directly. She nodded. When you filed your answer, were you asking this court to protect your legal rights? Yes. When you filed your motion to compel, were you asking this court to issue an order in your favor? She hesitated. Yes. When you requested a trial date, did you expect this court to resolve your dispute? Another pause. Yes. The courtroom remained perfectly still. Years on the bench have taught me that sometimes 3 honest answers resolve an issue more effectively than 30 minutes of legal argument. I leaned forward slightly. So help me understand something. Karen looked up. If this court had ruled entirely in your favor last week, I allowed a brief pause, would you still be telling me you don't recognize its authority? She opened her mouth, then closed it again. No answer came. That silence spoke volumes. I looked down at the case file. Everything I needed was already there. Months of filings, signed pleadings, electronic submissions, requests for judicial relief. The record was complete. I addressed both attorneys. The jurisdictional challenge is denied. The plaintiff's attorney simply nodded. Karen lowered her eyes, but I wasn't finished. Years of judicial experience have taught me that the integrity of the court requires more than denying unsupported arguments. It requires ensuring the process is not misused. I explained that parties are entitled to make legitimate legal objections. They are not entitled to invoke the authority of the court whenever it benefits them and reject that same authority the moment the case becomes difficult. Then I made a decision that surprised everyone in the courtroom because Karen had refused to participate further after her jurisdictional challenge was denied. I informed her that the court would not permit the proceedings to be delayed indefinitely. If she continued refusing to participate, the trial would not continue in the manner she expected. It would end. And within moments, Karen made one final decision that left me with no alternative but to bring the proceedings to an immediate and unforgettable conclusion. The courtroom had reached a point I always hoped to avoid, not because the legal issues were difficult. They weren't. The law was clear. The record was complete. The problem was that Karen Reynolds had stopped participating in the process altogether. Years on the bench have taught me that every person deserves the opportunity to be heard, but that opportunity carries responsibilities. A courtroom cannot function if one party simply refuses to engage after receiving an unfavorable ruling. I looked directly at Karen. Ms. Reynolds, your jurisdictional objection has been ruled upon. We are now prepared to proceed with the evidence regarding the renovation contract. She remained seated. She folded her arms. I won't participate. The words echoed through the courtroom. I gave her another opportunity. You understand that if you voluntarily refuse to present your case, The proceedings will continue based on the evidence properly before the court. I don't care. The plaintiff's attorney remained silent. He didn't interrupt. He didn't ask me to act. Experienced trial lawyers understand that some moments require no assistance from counsel. I addressed Karen once more. Are you refusing to testify further? Yes. Are you refusing to cross-examine witnesses? Yes. Are you refusing to present any evidence in support of your defense? She looked directly at me. Yes. Years on the bench have taught me never to assume someone fully understands the consequences of a decision made in frustration, so I explained them carefully. I told Karen that every litigant has the right to remain silent if they choose, but choosing not to participate does not stop a civil trial. It simply means the court must decide the case using the admissible evidence that has been presented. I asked one final time. Do you wish to reconsider? Her answer came immediately. No. The courtroom became completely silent. I noted her decision on the record. Then I turned toward the plaintiff. Call your first witness. Daniel Carter took the stand. His testimony was straightforward. He identified the written contract, the change orders signed by Karen during the renovation, the inspection reports confirming the repairs had been completed, photographs showing the finished work, invoices documenting the unpaid balance. Each exhibit was admitted without objection. There could be no cross-examination because Karen had declined to participate. The plaintiff then called the independent building inspector. He explained that he had inspected the property after Karen complained about the workmanship. His written report concluded that the repairs substantially complied with industry standards and that the remaining items had already been corrected before the lawsuit was filed. Again, no questions came from the defense. The evidence accumulated quietly, methodically, piece by piece. When the plaintiff rested, I looked toward Karen. Miss Reynolds, this is your opportunity to present your case. She never stood. I already told you, I don't recognize this court. That sentence, repeated once again, settled the matter. The courtroom had witnessed every opportunity being offered, every warning being given, every procedural safeguard being honored. Now, only one step remained. I closed the evidence file and looked across the courtroom. The trial, as Karen imagined it, was over. What remained was the court's final ruling and the explanation that every person in that courtroom would remember long after they left the building. The final moments of that case remained vivid in my memory, not because they were dramatic, but because they demonstrated a principle that every courtroom depends upon. The rule of law cannot function if participation becomes optional whenever the outcome appears unfavorable. Karen Reynolds had been given every opportunity. She received notice of the lawsuit. She filed a formal response. She submitted motions. She requested hearings. She asked this court to issue orders on her behalf. When those same proceedings no longer seemed likely to benefit her, she announced that she no longer recognized the court. Years on the bench have taught me that fairness requires consistency from everyone in the courtroom, including the parties themselves. I reviewed the record one final time. Daniel Carter had presented the written construction contract, signed change orders, photographs documenting the completed repairs, independent inspection reports, invoices showing the remaining balance due. Karen had been offered the opportunity to challenge every document, question every witness, and present every defense available to her. She voluntarily declined. Before announcing my ruling, I addressed Karen one last time. Mrs. Reynolds, the court has repeatedly invited your participation. The decision not to present evidence or challenge the plaintiff's case was yours alone. She remained silent. There was nothing more to add. I then announced my findings. Based on the evidence admitted during the proceedings, I found that Daniel Carter had substantially performed the work required under the contract. The independent inspection supported that conclusion. The remaining contract balance had not been paid without sufficient legal justification. Judgment was entered in favor of the plaintiff for the unpaid amount, together with any allowable costs permitted under the applicable law. The courtroom remained quiet. There was no celebration from Daniel Carter. Only relief. Months of uncertainty had finally come to an end. Karen slowly gathered her papers. The confidence she displayed on the first day had disappeared. Before dismissing the parties, I offered one final observation. Courts do not ask people to agree with every ruling. In fact, our legal system provides ways to challenge decisions through proper motions and appeals. That is how justice protects everyone's rights. But refusing to recognize a court after voluntarily asking it to resolve your dispute is not a legal strategy. It is simply a decision to stop participating in a process you previously embraced. As I left the bench, I reflected on the moment Karen first declared, "I don't recognize this court." She believed those words would halt the proceedings. Instead, they highlighted the very record that demonstrated she had already invoked the court's authority again and again. Her own filings told that story. Her own signature confirmed it. Her own requests for judicial relief made it impossible to argue otherwise. After all these years, I have learned that the strongest courtroom moments rarely come from raised voices or dramatic confrontations. They come from the quiet certainty of the record. Documents do not become meaningless because someone changes their position. Procedures do not disappear because they become inconvenient. And justice is not determined by who speaks the loudest. It is determined by who can support their claims with credible evidence and by whether every party has been given a fair opportunity to be heard. That case stayed with me because it reminded everyone in that courtroom of a truth that extends far beyond any single lawsuit. Respect for the legal process is not measured by whether you win. It is measured by whether you honor the process even when the outcome is uncertain. That is the foundation upon which every courtroom and every fair trial must stand.